All right, Mr. Kukeski, let's call Mr. McLeod's matter.
Good afternoon, Your Honor. Kuski. Cloud.
All right, and this is file numbers 24-6892 and 23-6748. And we're here for a docket call on both matters and some motions that are noticed up. And you know how we're proceeding today, Mr. Kukeski?
I do, Your Honor. At this time, my client would be offering a plea to the court that he would be pleading to in file 23-6748, count 1, resist obstruct, and then amended count 2, impaired marine safety. In file 24-6892, he'd be pleading to absconded and misdemeanor.
Okay. And we have amended informations. Do you consent to the filing of the amended informations, Mr. Kukeski?
I would, Your Honor, yes.
I did have a signed advice of rights. I'm not sure if the court.
I do, I have it.
Okay.
All right, Mr. McLeod, would you please stand and as best you can raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Put your hand down. And Mr. McLeod, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. At any time, if you've got any doubts, questions, or hesitations, just let me know. I'm happy to answer any questions you may have, and I'm happy to give you more time to talk to Mr. Kukeski if you need. Do you understand that?
I do.
All right, now I have to advise you the maximum penalty that you could face on the in the file 23-6748. You'd be pleading to resisting and obstructing a conservation officer. That is a high court misdemeanor punishable by a maximum of 2 years and or $1,000 fine. And count 2, marine safety operating while impaired. It's a misdemeanor punishable by up to 93 days and or a $300 fine and or 45 days of community service. The court will suspend your privilege to operate a vessel for at least 6 months to indefinite. The court can order you to repay the costs of prosecution and emergency response. In file 24-6892, you'd be pleading guilty to absconding on a misdemeanor bond as a lesser offense. That's a misdemeanor punishable by up to 90 days and or a $500 fine.
Your Honor, I believe that he hasn't been arraigned yet on the 24-6892. I don't know if we have to do that before the plea.
Oh, that's true. This was an arraignment date on that file. So in 6892, Mr. Kukeski will arraigning him on the amended information. Do you wish to have its allegations read?
We waive the reading, Your Honor.
Okay. Is a forensic center referral requested in that file?
No.
Okay. All right. So, Mr. McLeod, do you understand the maximum penalty that you could face for that?
I do.
Okay. And also, there's a pending contempt citation for failing to appear, and the factual basis you'd put on the record for the absconding would also constitute a factual basis for me to find you in contempt. And that penalty is a maximum of 93 days in jail and or a fine of up to $7,500. Do you understand that, sir?
I do.
All right. And the absconding charge, well, with it being a misdemeanor, it would be, I don't think it'd be consecutive anyway. Okay. All right, the plea agreement provides in exchange for your plea to those charges that I outlined, the prosecutor will dismiss the original counts and the habitual offender notice. And there's a requirement, there's a sentence agreement that they would run concurrently, which I think with the plea to the misdemeanor would be required by law in any event, but the sentence agreement just locks that in. And also a sentence agreement for no immediate jail at the time of sentencing. Do you understand the terms of that plea agreement? Mr. Kukeski, is that a full, fair, and accurate statement of his terms?
It is, Your Honor.
Mr. Juliet?
Yes.
I'm sorry, but whose hand?
Okay,
I'm sorry.
That's okay.
All right, Mr. McLeod, that sentence agreement is not binding on the court, meaning if I did not want to follow it, I would not have to. But if I did not follow it, you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that? Now, there's one exception to that. That's if you were to engage in any misconduct between now and then, including new crimes or violations of court orders, then by that misconduct, you'd be forfeiting the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
I do.
All right, Mr. McLeod, other than that plea agreement, has anybody promised you anything to get you to plead guilty today? Has anybody threatened you to make you do so? Is it your own free choice to enter those pleas?
Yes.
Knowing all this, how do you wish to plead in file 6748 to the charge of resisting, obstructing conservation officer list offense?
Guilty.
How do you wish to plead in count 2 to operating a vessel while impaired?
Guilty.
And how do you wish to plead in file 6892 to absconding on a misdemeanor bond?
Guilty.
So, Mr. McLeod, back in September of 2023, were you operating a motor vessel on the waters of the state of Michigan?
Yes, sir.
And was that within the confines of Sheboygan County?
Yes, sir.
Before you had operated that vessel, before or during, I guess, had you consumed alcoholic beverages? And did you end up having any kind of breath or blood test to determine the level of alcohol in the body? Do you recall what the results of that test were?
We have 1-3.
Okay, and do you acknowledge that that is above the legal limit in the state of Michigan?
I do acknowledge that.
All right. And did you have some contact with a conservation officer, Listenfelds?
Yes.
And did that officer give you some lawful commands?
Yes.
And did you fail to immediately obey those commands?
Yes, that's correct.
All right. And then you were on a bond in that case representing yourself in that matter. Is that correct?
Yes,
And did you fail to appear for a court hearing in that file?
that's correct.
And then that resulted in a forfeiture of your bond?
That's correct.
All right, Mr. Kukuski, are you satisfied with the factual basis to all 3 counts?
I am satisfied, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Kukuski, are you aware of any other promises, threats, or inducements?
I'm not aware of any.
Ms. Goodrich?
No, Your Honor.
And Mr. Kukuski, do you believe that I have complied with the requirements of MCR 6.302?
I believe the court has.
Ms. Goodrich?
Yes, Your Honor.
All right, Mr. McLeod, we've asked you a lot of questions. We've given you a lot of information. I just want to confirm for you that that's your own free choice to enter these guilty plea hearings today.
That's correct.
Well, Mr. McLeod, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I'll accept your pleas in both files. I will also find you in contempt for the pending contempt citation for failing to appear. We need to set a sentencing date. So let me ask you, the intent of that sentence agreement, no immediate jail, no additional jail at the time of sentencing, does that contemplate that you remain in custody until that date?
Yes.
Okay. Agent Fagan, Agent Young, I know you're kind of short-handed. Do you know how quickly you could get a pre-sentence report done in, I would only, let's see.
I do have a motion before the court on the bond issue. I would forego the motion with regards to the absconding charge.
Okay, gotcha. Okay, well, let's hear the bond motion before we set a sentencing date.
Very good, Your Honor, and thank you. Your Honor, I know Mr. McLeod has had, I guess, some difficulties with court here. He certainly admits those, acknowledges that, is moving forward in positive direction with this case and with his acceptance of responsibility today, Your Honor. He's taken another step in that positive direction with the court. I did provide, as part of my motion, several letters from individuals who he's contracted to do work for, outside work that would require him to be working outside. And obviously, we're getting into some of the colder months. Those jobs, I believe, if he's continued to be incarcerated, he'll lose those jobs. He's got money out there, materials. He's the sole provider for his family. He certainly acknowledges he's got to come to court. He missed his court appearance. He was arrested on a warrant, and he sat sentence. He sat probably 45 to 50 days, I would imagine. He's as close to 60. But we're asking for some mercy from the court to allow him on bond. I we would take a tether if Your Honor thinks that that would be appropriate or feels that would necessarily make him appear for court. He will be here for the sentencing. He obviously, just to please, the resist obstruct is the charge that he has pled to, that the court would be sentencing on the highest, I guess, possibility of incarceration. He doesn't score up too high in my book. I didn't have him scoring up very high at all. If he does violate and he doesn't show up, he obviously loses the agreement of any further incarceration or no immediate incarceration that me and the prosecutor have entered on that. I think the message has been sent, just to say the least, and we're just asking the court look into its heart. And the judge one time told me not to sentence or make a decision for placement of anger, but to step back and just reasonably put forth an order or an opinion. And I think that's no better wisdom has been said in these matters. And so we're asking the court just for a reinstatement of his bond. Whatever conditions, additional conditions, the court wants to put on there, we would gladly follow those conditions and abide by those.
Okay. Well, I assure you, I'm not angry at Mr. McLeod. We've just been trying to move the case forward and in a responsible way. Ms. Goodrich, people's position.
Oh, Your Honor, I would ask to deny that motion. Apparently there's some miscommunication between Mr. Kirkowski and I, but my intent in that plea agreement was that Mr. McLeod would sit until time of sentencing and then no immediate sentencing thereafter. He has not done well on bond. So it's my intent to get to sentencing and include that matter. So I would ask the court to deny that based on his performance on bond.
Are there other violations that he's been brought to the court on? Yeah,
No, I don't.
I don't think I was familiar with it.
All right, well, I guess is your position that if he's not in custody from today forward, that entitles you to withdraw from this plea? Is there some ambiguity about the meaning of that sentence agreement, or?
Yeah, I think there was some miscommunication. I thought the intent and what we had discussed is that he would sit until sentencing, and then that's some of the reason that consideration was given in the plea offer that was given.
Okay, and that is typically
on me. I did not.
That's typically the practice where it says no immediate jail at time of sentencing versus sometimes if it's going to be at time, then there's a stipulation for release. I guess that brings me to my next question. Agent Fagan, Agent Young, I know you're short-handed. Could counsel approach for a second? All right, and back on the record, I wanted to consult with counsel about possible sentencing dates. And so, Mr. Kutkowski, would you waive the requirement of a pre-sentence investigation in this matter?
I would, Your Honor.
Ms. Goodrich, would the people waive it?
I would.
Okay, it's a high court misdemeanor. Obviously, it's not a case where we'd be sending him to prison, so I think we can certainly waive the requirement of a pre-sentence report. That means, Mr. McLeod, that we can schedule your sentencing on a much more expedited basis. So I'll deny the motion to reinstate bond at this time, but we'll schedule sentencing for 1 week from today, September 17th at 11 a.m. And I'll hear allocution from both sides at that time. If you wish, either side can file a written sentencing recommendation memo, but it certainly isn't required either. But I won't require the DOC to prepare any pre-sentence investigation. All right, so we'll see you next week at 11 a.m.
Thank you, Your Honor.
Thank you.